I'm Jeff Hampton with the Hampton Law Firm. Thanks for joining us today on our YouTube channel. Today I want to talk to you about assault charges in Texas, how to beat an assault charge in Texas, and I want to break down the law for you, okay? If you wait around to the end of this video, I'll also give you a free ebook, a free resource, what to do if you have been charged with a crime in Texas. Now maybe you're facing an assault charge. How do you fight to keep this off your record? How do you make sure that you don't have to face any potential jail time? Well, the first thing we need to do is break down the crime of assault. How do we look at it? How do we know if this is a misdemeanor? Is it a felony? Well, let's start with the lowest level of assault, assault by contact. Assault by contact is a Class C misdemeanor. It's punishable by only a fine of up to $500. So some people have the temptation to say, well, then it's probably not a big deal. Who cares? Here's the problem. Assault by contact, if you pay the fine, if you walk in and you pay that $500 fine, you are pleading guilty, and it is now a conviction that is on your permanent criminal record. So many times, many of these agencies, particularly if it's domestic violence assault related, they're going to want you to do some fingerprints, and they're going to want to make sure and keep this as a part of a permanent criminal record. And sometimes they'll even want to put you in a database of those who have been convicted of an assault. So one of the things we want to do is make sure you understand that you need to fight that, even if it's a Class C misdemeanor, okay? Now, what do I mean by that? So when we say, what are the elements of assault by contact? The state of Texas must prove beyond a reasonable doubt that the individual, the alleged defendant, injured the victim, but not as the way we think of it. It may only have to be offensive contact. So if one person contacts another person and it was offensive, that's all they got to prove. So if I do something, if I walk up and I push you a little, but it didn't hurt, but you're offended, technically, that's offensive contact, which I know sounds kind of crazy. How many of us have done that just playing around or goofing off? The reality of it is that's what the law says must be proven. So one theme that you're going to hear me talk about as we go through this is, let's say the alleged victim says, okay, look, I got a little upset at the time. I don't really want to pursue this. I wasn't really hurt. I wasn't even really offended at the time, but things just got a little out of hand. I was emotional. Please understand, if the alleged victim doesn't want to prosecute, that may be one of the quickest ways, if they're willing to clear up what actually took place, that may be one of the quickest ways for you to be able to take care of your case to get it dismissed, okay? But that's offensive contact. That's assault by contact. That's a Class C misdemeanor. Let's look at the case, or let's look at the charge above that, Class A misdemeanor of assault bodily injury. What must be proven there is that the state of Texas must prove beyond a reasonable doubt that the defendant intentionally or knowingly contacted another person and caused them physical pain, okay? How do you prove physical pain? Well, that can be proven by the person claiming they were hurt. It could be proven by showing some sort of injuries like bruising, something along those lines. And then that would be a Class A misdemeanor punishable by up to a year in county jail and up to a $4,000 fine. Now, if you take it up to the felony level, you're not going to be talking about, let's say a weapon was involved. If a weapon was involved, or something that in its intended use could be seen as a weapon, you could now be talking about an aggravated assault with a deadly weapon. Now, I did a separate video on that one crime all by itself, and I encourage you to go back to my playlist and take a look at that, the video series that I did on it. I break that down in more detail. But generally, if a weapon is used in the commission of an assault and the person felt they either suffered injury as a result of that weapon or they felt in fear of serious bodily injury or death, you could be talking about a second-degree felony, up to 20 years in prison and up to a $10,000 fine. Then there is aggravated assault, serious bodily injury. Let's say there's a fight that takes place, and as a result of that, they have a serious bodily injury. What's that defined as? Permanent loss of use or a protracted loss of use of a bodily organ, like an organ of your body or a member of your body, meaning your arms, your legs. So if you end up crippled, if someone ends up crippled, if someone loses an eye, if someone is not able to function as they had functioned in the past, that would fit the description of a serious bodily injury. Once again, you're talking about a very serious charge in that situation, a felony where someone could go to prison for an extended period of time if that were to come about. So the question becomes, okay, Jeff, how do we defend these types of charges? Well, these felony charges must be proven beyond a reasonable doubt by the state of Texas. And if there is information that may exist at the very beginning of the case that can show that this maybe cannot be proven beyond a reasonable doubt, every felony in Texas must be indicted by a grand jury. So if the alleged victim doesn't want to prosecute, or if there are witnesses who are available to provide information that would show that perhaps this did not take place the way that the police are claiming, it's important that your attorney provide information so that the grand jury can do one of three things. Number one, they could always keep it as a felony. Number two, they could drop it to a lesser charge. For instance, drop it from an aggravated assault down to a Class A misdemeanor assault, a lesser charge. Or they could do what's called no bill the case. No bill means that the case is essentially dismissed. You've been exonerated. So that's the quickest way to address a case like this. But if an alleged victim does not want to prosecute, it's important that desire be made known early in this process. Okay. So the other way, of course, you say the big way to defend, let's say, well, what if the alleged victim is claiming that they're righteous in what they did? They don't want to drop the charges. Well, many times we find that people act in self-defense. And please understand this. If you acted in self-defense, the state of Texas must prove beyond a reasonable doubt that you did not act in self-defense. That's proving a negative. Very difficult to do, okay? And so if there are witnesses who would establish that, for instance, the other person was lunging at you, or they came at you in an aggressive way, or they came out and it looked like they were pulling out a weapon, or maybe they made a threat against your life as they made a move in your direction, these types of things can very much affect whether or not the action that took place was in self-defense and whether or not the state of Texas can actually prove the elements of the assault charge. Okay, so my point on that is this. Whether it's a ticket, don't just go pay the ticket. If you pay the ticket, you're convicted. Or if it's a first or second degree felony assault charge, the reality of it is these are very serious charges that you do not want on your record. So if you need some assistance with your legal case as it relates to this, don't hesitate to contact the Hampton Law Firm at 817-877-5200. I promised you if you waited around to the end of the video, I'd also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Click the link below, and we would be happy to send that over to you. Thanks again for joining us today. I look forward to seeing you on our next video series.